It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Here at the WTAN radio studios with myself and my co-host tonight. Hopefully you all have been tuning in every Tuesday at the 5 o'clock hour for FLA Law. This is your live legal call-in talk show where we answer your questions on the air. I am here with myself, Jacqueline Bryant. Hopefully you guys remember me. I've been gone a couple weeks now, and my co-host Lori has been holding it down a few of those weeks. And she's here with me again tonight to answer your legal questions. I, of course, want to give you the rundown as far as how to get in touch with us tonight and get your questions in, let you know how to find us, and, of course, allow Lori to reintroduce herself as well. As you know, we are live on the radio, so if you have a question, you're tuning in at AM 1340 or you're listening on 106.1 FM, certainly give us a call here at the station. The number is 727-441-3000. Again, that's 727-441-3000. That is the direct dial to call us tonight in the studio and have your questions answered live on the air. Now, if you are not able to listen to us on the radio, but you can listen online, we are on Facebook Live tonight, as always, streaming from our firm Facebook page. So if you have a Facebook account and you want to drop a question in the comment section, you can do that tonight as well. You can find us at Perinick, Caulfield, Averill, and Noyes Injury Lawyers. We are on that Facebook Live right now. Wave, Lori, everybody out there. We do have a few viewers watching. That's Perinick, Caulfield, Averill, Noyes Injury Lawyers. Perinick is spelled Pernicch. Also, if you are wanting to watch online but you don't have Facebook, we're on YouTube as well. YouTube can be found under the same name, Perinick, Caulfield, Averill, and Noyes Injury Lawyers. Go check out our live YouTube feed. And again, we'll answer your questions from there if you want to drop them in the box. It looks like we already do have a caller, which is excellent. So let's go ahead and get that caller on the line. Can you hear us, caller?
Yes.
Hi, how are you? Go ahead with your question.
Well, good. I'm calling on behalf of an elderly person
Okay.
who is just about getting ready to get out of rehab, who was in a horrible car accident. And she had a two-part question.
Okay.
She heard recently that there was a diminish in the length of time you could file a lawsuit.
Right.
And her second problem is she lives down near Tierra Verde, but she's heard such wonderful things about your firm. She's not real comfortable with like FaceTiming or anything like that. Was wondering if there were like a closer office or any accommodations that she could make to meet with you.
Excellent questions. Do you want to take those, Lori?
Sure. Give it a start at least here. So yes, the recent law was changed with respect to how long a person has to bring a personal injury action. The legislature met and voted in almost record time, and as of March 24 of this year, the law is now that you must bring a personal injury action within 2 years of that accident date, versus it used to be 4 years. Really, forever has been 4 years. So,
well, her accident happened on January the 6th of this year, so she's well within the limit.
Yes, all right. Well, she would in that situation be covered under the earlier version of the statute.
Correct.
And the other question posed, kind of relating to a person maybe doesn't have as much ease of travel type thing and that sort of thing. And I think that could be answered in a couple ways. One is we do have offices that we meet clients throughout
Absolutely.
the county, including in St. Pete, which actually, Jacqueline, I mean, you spend a lot of time at the St. Pete office because you're a St. Pete person.
Yeah, I'm a native of St. Pete, grew up, born and raised there. And so the good news about that, if she's able and someone can get her there, we have kind of two options that we could do. Is our St. Pete office locations on First Avenue South, just a few blocks down from the YMCA, if you're familiar where that is, or the big Central Station bus corral there. It's just a couple blocks down from there. So if you're familiar with that area, then that would obviously be a location where we would be able to meet with her in person. But our attorneys are always happy to make arrangements to come directly to her. So if she's wants to meet and have a consultation, we can certainly schedule and try to coordinate if she's unable to travel or drive. And the virtual world is not necessarily something she's able to do.
Everybody.
And we understand that most definitely. So we do have a St. Pete office.
She would love that very much.
Yeah. So it sounds like she should be okay in terms of the change in the laws impacting her statute of limitations. And our St. Pete office might be the location that would be more convenient for her. But of course, you can have her call our main office line, which is 727-796-8282. And our intake department would be more than happy to speak with her and try to coordinate and arrange the best possible way to meet with her and talk to her about her case.
And let me thank you. Yes, thanks very much for calling in on behalf of your friend and encourage her. And I hope anyone else listening, and a lot of times people, maybe they don't want to get involved with the legal process or they're not sure. It's not a bad idea just to call and let us talk to you a little bit.
Exactly.
And help give you a little guidance on that. So appreciate that question on behalf of your friend very much.
Okay, well, thank you so much.
No, thank you for calling. I hope that answered your questions.
Yes, it did. Thank you.
Have a good night.
You too.
Thank you so much for the calls coming in already. That does free up a line. So if anyone is wanting to get their legal questions in early, definitely do so. We are here until 6. The number once again is 727-441-3000. Again, that's 727-441-3000. That was a great question because I know there is a lot of confusion about the new change in the law.
Oh my goodness. It's a very, very complicated change in many respects. The statute of limitations, that 2 years versus the 4, that's kind of straightforward, really. But there are so many other issues that have been raised by the new law that are going to keep lawyers and courts busy for a very long time.
I agree with you, especially since the language is being challenged as to when it might be effective.
Yes.
So that is also going to create some issues. So again, like Lori said, if there's any questions you have about the new change in the law, you're just not sure how it impacts your case, don't hesitate to give us a call. Even if you think that you may not have a case, it's better to run it by experienced personal injury lawyers before you make some sort of decision. Looks like we have another caller already on the line.
We do. It's Sam from Largo. Sam, are you there?
I am.
Hi, Sam. How are you?
I am fine. How are you?
We're doing well tonight. Go ahead with your question.
Thank you. So I witnessed an accident about a year ago, and now I've been subpoenaed by a lawyer for a deposition.
Mm-hmm.
My question is, do I have to show up to that deposition?
That's a great question. So if you were subpoenaed, and obviously I can let Lori chime in, but legally you are obligated to appear for, that event. And it sounds like you said it was a deposition. So as a witness, you may have pertinent and valuable information that could help essentially, resolve some issues in that litigation matter. And although you are independent, you have no stake in the outcome and probably does inconvenience you from your time and your resources, but it does certainly help resolve disputes. And that's how we do things here in America. We're a society where we resolve our disputes in the justice system this way. And so witnesses like yourself, who sounds like you were probably kind enough to wait at the scene and provide your information, and somehow they found out about you, and now they're asking you to come in. So technically, yes, if you didn't, I guess there could be some legal ramifications. Sometimes there's sanctions and things that might occur if you chose not to. So it's usually in your best interest to try to comply. And if it's at a time that's inconvenient or a date that just doesn't work for you, or you've got something important going on at work, then I can probably say, you should reach out to the lawyer who subpoenaed you to see if there's somehow some way to re-coordinate that time or the date. Would you agree with that, Laura?
It would be very unusual for a lawyer's office not to work with a witness's schedule and their needs. And it's the kind of thing, it's so often I hear complaints. I make some of them myself about our judicial system. But the truth of the matter is, it is, with all of its flaws, it's the best in the world. It does depend on the ability to get evidence. So it's so important to be willing to participate. And with a subpoena, I mean, honestly, you really are. It's a legal process issued by the court, in effect, and so you don't really have the option not to appear. How often? Is that a problem for a witness? It kind of depends on the lawyers involved and the importance of the testimony. But I wouldn't be advising anyone to ignore a subpoena because it really is a legal process, and so you should contact the lawyer's office if there's a problem with appearing.
Right.
And it won't be as bad as you think, most likely.
and I would say traditionally it's probably a very simple process. And if it can be coordinated to work with your schedule, it's best to comply. Are you risking being thrown in jail if you don't? I mean, I'm not going to go that far and say that. As Lori said, it's.
I'll tell you, many years ago, I had a case, and it was a medical malpractice case, and it involved a doctor who was unrepresented. He didn't have insurance or whatever, and he didn't appear for his deposition. And the judge in question, who shall remain nameless, God rest his soul, he's gone on, but we were actually at a contempt hearing at which the judge announced he was preparing to put the doctor in jail, which was unheard of, and it did not happen. I mean, and we certainly weren't seeking that in that situation.
Right, that would be pretty extreme.
Just a little bit, So, but we like to avoid those things. And now, because of what happened during COVID, the depositions now. Almost all actually now are appearing via Zoom.
Oh, that's very true.
So how often do we have witnesses who are actually sitting in their car with their phone appearing? Which I don't know if that's the best way, but it's certainly a convenient way, and it does help a lot of times when there's a little bit of a time crunch. And
that actually segues into a good point. So Sam, I don't know if you're still on the line, but that was a great question, and hopefully that answered your question. And it does free up the next line for a caller who, if you have any questions about what we've been discussing so far, or even something off topic, we're okay with that. We can always pivot back to what we're on. We're good at that. So feel free to throw your questions out there. The lines are open. It's 727-441-3000. Great questions so far. But that actually does segue into a really good point. So depositions, and I've been hearing a lot of attorneys, kind of just saying that they're going to kind of stick with doing it through Zoom, even though COVID is now less of a threat and it's not necessarily, mandated to kind of do it that way. You can still do your depositions in person now, but it seems that that's kind of the way things are starting to occur more frequently. And I've heard some criticism from judges about Zoom hearings and the way parties might appear. Do you find that kind of trickles over into depositions in terms of of course, preparing your client for
if
Zoom?
It's one of our clients, we're of course going to counsel them. But I will say that because, a deposition from the point of view of the plaintiffs, we represent people who've been injured, that is intended. The defense has the right, of course, to take the person's deposition. And in that process, we as their lawyer are hoping to make the best presentation for that person. And so how you appear, your demeanor, all of these things are a big factor. And that is a little trickier when you're in a Zoom type setting because it just doesn't feel that connected. It's, it was certainly, I'm grateful that the legal system was able to utilize that during the COVID situation because it did allow, even though everything slowed down, but it did allow a lot to continue, which was wonderful. But and I still find it convenient, and I think most people do now. Yeah.
Oh, it's helped with my mileage on my car quite a bit.
It has. Oh yeah. But it is a kind of thing where there's, as good as it is, there is just a slight distance in terms of the connection that you make. So I think it's something that I'm sure it's going to be with us. And there are a few lawyers, but not many.
Yeah.
I have a live deposition coming up next week. That particular defense lawyer just prefers to do them live, which I'm fine with that. Yeah.
Yeah, and I think the issue I may have, and for someone like our caller Sam, who had called in a minute ago, if it were Zoom and my Zoom appearance, my advice would be just be mindful of the fact that you shouldn't have anyone in the room with you, no roommates or spouses or even pets. Those things can be distracting because as you're giving your testimony, the parties want to make sure that you're the only one there giving that testimony. No one is influencing what you're saying. And then, of course, you want to present professionally. I've heard some horror stories of people appearing for Zoom depots and they're in bed and they're in their pajamas, or like you said, they're in their car or driving.
Yeah, no driving when you're on the video.
Do not drive and do a Zoom deposition. So those are obviously the new things that I've seen kind of pop up that you might not have necessarily seen pre-COVID. But in general, there's still some, I think blanket rules or suggestions that you might have or tips that are going to apply whether it's Zoom or in person, right?
Oh, yes.
Anything in particular that stands out to you?
Well, one thing that is, in a sense, Zoom could make it easier, but people need to recognize they really want to be sure they understand the question and listen to the question. And then what you're going to do is you're going to answer the question truthfully, of course, but really shorten to the point. It's not a place to volunteer information. You don't need to figure out what the other lawyer wants to know. You just answer the question that they've asked.
Right.
Now you have, with the Zoom setting, what kind of adds a level of complexity to it is the technical difficulties that can arise.
Sure.
Even if everything's going pretty well, there seems to be sometimes a little bit of delay or distortion, or your screen will freeze up. And more important than usual, not to talk over the other party, which in conversation we'll tend to do, but you can't do that in the Zoom setting. And you really shouldn't do it even if you're sitting across from someone in a live in-person deposition, because, of course, we have the court reporter taking down what is being said, and that's going to be the official record, and they can't do that very accurately if it gets confusing with people talking over each other.
Absolutely. It's very difficult. And sometimes people just assume a normal conversation that, I already know what you're about to ask me. And so they'll interrupt and they'll start responding before they even heard the entire question. And I think that's one of my no-nos, if you will. Make sure you've heard the full question and understood the full question before you respond. So it's just good to kind of just take a pause after the question is asked instead of kind of rattling back and forth, question, answer. Take some time to make sure you heard the question, understood it, then give a response.
And how many people are concerned about being in a deposition because it's foreign to them? It involves a legal process. They're not familiar at all with that. And they worry that they're not going to understand, or they're going to say something that is the wrong thing. Well, of course, the wrong thing, you're not going to say the wrong thing, because as long as you're saying the truth, it's not going to be the wrong thing.
No wrong answer.
But it is absolutely true that we lawyers can get going in long, convoluted questions that to us make perfect sense, unless somebody actually points out to us that, let's kind of run on, it didn't make any sense at all. And we'll use words like prior, subsequent, all things that in common language people don't necessarily speak that way. And so the witness's job is only to answer what they understand, and not to be bashful. I'm sure you do the same thing. I always say, don't be bashful. If you don't understand, just say so, and they'll rephrase the question.
Absolutely.
And that's key. And then you realize it's not a memory test. It's not a question. It's not a test to get the right answer. If you don't remember a date or a time, you just say, I don't remember.
Absolutely.
Try to, of course, but if you don't, it really doesn't matter. And so normally what we'll do, obviously, when a client of ours is going to give a deposition, is we're going to spend some time in advance preparing them, going over some of these simple rules and also the specifics of their own case, naturally, and kind of putting them at ease that it's not a process to be afraid of.
Exactly.
Actually, it's a good move forward in the handling of their case.
Exactly. And that's a good point because, generally speaking, that's really the one chance the defense lawyer gets to sit down and talk to you and hear about your case other than, when you ultimately end up in a courtroom at a trial. And so because that is their opportunity to meet you and hear about your case and how it's impacted you, I think demeanor is also really important and how you handle yourself in that deposition. And if you're easily testy or you're agitated and that comes through, when you're giving your deposition, I think that can sometimes, hurt, the way things proceed. So I think it's really important just to be mindful of the way you present yourself and how your temperament is during the deposition, because
Absolutely.
believe it or not, it does have an impact.
Oh, yes. And of course, what happens, as I said a moment ago, of course, this is not the trial at all. And our client, the witness, is never going to convince the other side of the merits of our case, just like they're not going to convince us. I mean, in the adversarial system, we have attorneys on both sides, and our jobs as lawyers is to present the facts in the way most supportive of our client's position.
Exactly.
So if the client, understands that and then understands what you said, which is, you just can't react. I always tell the client, just if lawyers are just people. Most of the lawyers we deal with are quite pleasant and professional.
Right.
Every so often, you'll find somebody that you kind of want to swat.
This is
but
true.
You can't. You have to go, nope. And you just have to let it roll off your back, basically, and kill them with kindness, so to speak, because it's an opportunity for the defense lawyer is going to size up the witness, the client, and how will that person appear if the case does go all the way to a jury trial. Very few cases do, but every case is measured against that. And, so they get a chance to see how that client is. And if you react to something and become a little bit angry or whatever, that can be that's going to be a negative factor. On the other hand, if you present yourself very pleasantly and without becoming overly emotional in a negative sense. Now, a lot of times we'll have clients that become the women, and being a woman myself, you are too. It's like, we can become emotional and maybe shed a few tears. I mean, obviously, you don't want to do that per se, but it's not a process that you can be yourself. And so if you need to take a break, that's never a problem.
Exactly. Yeah. And I think even still, like you made a good point when we want to take a break, because I think what I notice the most is not necessarily clients that are rude or, agitated. Most clients, they come in and they're very pleasant. But as time goes on and the deposition goes longer, the pain starts to kick in, their neck hurts, their back hurts, they're tired of sitting here. That's when you start to notice a change in the attitude and the demeanor. And so I always tell my client, before you get to that point where you just want to snap, take a break. We can take a break. You can stretch. You can stand up. As long as you're answering the questions, I think that's okay, right? Oh, right. And that's a part of preparation. It's just if you're going to feel uncomfortable, if it would help you to stand up, you just say to the attorney, would it be all right if I stood up? And it's always going to be all right. Exactly.
And they're going to offer the opportunity to take a break if that would be helpful. And sometimes, like you say, I mean, really obviously it's difficult to sit for extended periods because most of the people that we're dealing with are going to be people dealing with chronic pain to one degree or another, and so that can be an issue. And that makes it hard for anybody to maintain their focus. So that's acknowledged within the process. So you don't, it's not an endurance contest.
Exactly.
You can absolutely ask for a break at any time, and that's never an issue. And most of these depositions we find, they are difficult for people. They may last 1 to 2 hours and sometimes a little longer, depending on the style of the lawyer or the nature of the case.
Right.
And the lawyer on the other side doesn't necessarily appreciate, what the difficulty for the client. But that's what we are there for as the client's attorney and representative. So if I notice, I'm sure the same with you, obviously, if you notice the client is just looking stressed, acting like maybe they need a break, then it's a time when we'll intervene and say, this would be a good time for a break kind of thing.
Exactly right. And that does sound like it's a good time for us to take a break here on the show. You see how that worked? Perfect segue. So we are going to take a quick, just 2-minute break, but of course the lines are open. You can give us a call to ask any of your legal questions. Lori and myself are here to answer those questions. And the number once again is 727-441-3000, and we will be back shortly.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman. In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
And we are back with FLA Law on the radio. My name is Jacqueline Bryan. I'm one of the personal injury attorneys at Pernick, Caulfield, Averill, and Noyes. And I am here once again with my co-host, Lori Robinson. Unfortunately, we didn't really get to do our intros. We had got right into answering the legal questions. So, of course, hopefully you recognize our voices by now. But Lori has been here with me so far since the beginning of the show, helping answer all your legal questions. I think we had some audio issues on our Facebook Live, so hopefully we have rectified that. If not, like I said, we're also on YouTube. So if you're wanting to watch us online and there's no audio on Facebook, feel free to jump over to our YouTube channel, which is Pernick, Caulfield, Averill, and Noyes Injury Lawyers. And you should be able to watch it there. But hopefully you're able to tune in on the radio, which is, of course, 1340 AM and 106.1 FM. So before the break, we were talking about depositions, which is kind of a key or integral part of the litigation process. But there's so many other, tips that we can really provide and try to help people that are going through litigation and dealing with kind of the hoops and hurdles that might present itself that you may not necessarily think about when you're, going into a lawsuit or you're filing a claim on your behalf and you have a lawyer representing you. These things don't always pop out or necessarily come to the forefront of your mind. But in a personal injury setting, I think one really important piece of advice I would give is being mindful in this day and era of the things you put on the internet.
Yes.
Social media is so prevalent prevalent these days. Even now, when you get your discovery served from the other side, it's full of questions all about our clients' social media usage and habits and what accounts they might have. So it tells you that this is definitely not going away anytime soon. Do you have any tips for our listeners, Lori, about what they should be mindful of when it comes to their social media activity if they're involved in a lawsuit?
Well, sure. In fact, but it causes me to reflect on how things have changed. I'm a little bit old school. I've been practicing with our firm for close to 25 years and almost 20 before that. And you've been with the firm
11 years now. Yeah.
Right. So you're the young generation. There you
yes,
go.
I can say that.
That's right. And I'm the, I'm more mature generation, whatever, but elderly, not elderly.
Seasoned.
But the thing that's interesting, before social media, you might get asked in a lawsuit when you're in a deposition setting or whatever, you might be asked about pictures, and you're still asked about to produce pictures from maybe activities or maybe you went on a trip or whatever. Well, once we moved into the social media era, that everybody from seasoned to young is involved in, but particularly younger people. Many people kind of live their lives on Facebook or Instagram or what some of the others you'd be more familiar. I know Facebook, but
there's so many out there. Yes. I can't even name them all.
And so what ends up happening if you have been in an accident, and you're bringing a claim, you do need to be very mindful of the fact that. Unfortunately, yes, it's a little bit invasive of your life for sure. But I mean, if you've been injured and you certainly have a right to reasonable compensation for what you've gone through, you want to be sure that you don't do something that jeopardizes your claim and allows the defense and the insurance company to put you in and frankly, a false and unfair light. So you really don't want to be posting things on Facebook that are related to the accident at all. And you need to be very mindful of your activities, because what ends up happening, and this kind of connects back to our discussion about depositions, is your level of activity is going to be the subject of questions.
Exactly.
And you may not remember that you posted something about, going hiking or whatever at some point in the past. And they will actually ultimately be able on the defense side to gain access to your Facebook photographs that would be relevant to activities.
Exactly.
So it is something to be aware of. We always caution our clients, obviously, that you really don't want to be posting things on Facebook while you've got the claim pending. You can't, once it's there, you can't delete things and try to hide things. That's the wrong thing to do, and is really not permitted. It would be actually fraudulent to do that. But so you just need to be mindful of what the situation is, and also make sure your lawyer knows what the situation is.
Oh, that's key. That's very key. It's better to be upfront and forthcoming with your attorney about what might be out there. You definitely never want to be, I won't say never, but there's times that it's inevitable you're going to be on the defense, but you would prefer to be on the offense instead of having to defend new information that's coming from the other side that we could have, addressed in the beginning if we had known about it. So it's very important, I think, to disclose it to your lawyer, whatever it may be, so that it can be addressed, proactively, if you will.
Right.
And even things as simple as, people may not even think about it, but TikTok, all these TikTok dances and these TikTok trends, it just thinks like, oh, I'm just doing something fun with my children, or, just a cute little video, but you're maybe doing motions and movements with your body that, maybe in your deposition, you said you couldn't do certain things, but, in the video, it seems as though you can. And no one knows if you're wearing a back brace during that video, or if you had to take an extra pain medication after that video, or anything like that.
Or were you laid up the next day because of
Exactly. And so these are the things that, exactly like Lori mentioned, where it could be presented in a different light by the other side. And so it's very crucial that you're kind of mindful of those kinds of things.
Now, I do want to say, you got to live your life.
Sure.
So, it's not that we're saying, don't live your life, but you need to be conscious of that and allow us as lawyers, if we're handling the case, and any lawyer handling personal injury cases would say the same, to kind of guide you and counsel you on that. And for the most part, probably not a time to be putting all this sort of thing on film.
Right. And that's really prevalent these days. I think everyone's a vlogger. Everyone, we've got lifestyle vlogs, and I'm guilty of watching a lot of those channels where people document their travels and different things they do. And, it can be entertaining, but if you are a plaintiff in a lawsuit, then that becomes evidence. And your travels, the things you do, the vacations you take, that's all relevant. And I had a client not too long ago who was really concerned about why do they want to see my passport? It was one of the things that they requested in the request to produce. They want to see your passport and all the stamped pages. And I'm like, well, what does that have to do with anything? Well, your travels and the places you've gone, especially since the accident, are going to be something they use to determine how limited you are and how much you're capable of doing. And so that is relevant, unfortunately. Sure. It does seem intrusive, right? It seems like, well, what does my travel life have to do with this? But it is something that we typically have to produce in discovery. So that's a good tip, Lori, in terms of that. Now, one new thing I'm seeing, and I thought, this is interesting, but I get it, is now the Apple Watches and the Fitbits and
oh my goodness,
yeah,
I never thought of that.
Yeah, really. So I'm like, wow. So it even that goes so far as to say, well, how active are you on your watch? Are you getting your 10,000 steps? Does that change after the accident? How can we see if that's gone up or down? Are you one of those religious, people that have to get your 10,000 steps in every day, but you said that you can't do those things? So those are things that you kind of got to be mindful of. Yeah.
That's interesting. I haven't had that specific situation come up quite that precisely, but obviously you have, and
I've seen it.
Definitely can see why that would be very legitimate.
Yeah,
very legitimate. And it kind of in these situations, the real key is for the person not to get into a position where they're saying something that it can be made to appear that they weren't telling the truth or they were minimizing it.
Exactly.
Many cases, there are people, personal injury ranges from people that have catastrophic, severe injuries to people that have, something middle of the road, to people that have something that is life altering to some extent, but fortunately, they're able to live their life and continue.
Yeah.
So it's not that you don't have a claim if you are still able to live your life, pretty close to how you were before.
Exactly.
But you just don't want to provide ammunition, so to speak, that can kind of mislead on what your situation is,
Right.
So, yeah. But yeah, that's a good one because, I think about on these watches now, like you can share, circles and that sort of thing. And so you can share activities.
Close your rings and all that.
So
right?
I know when my brother, who lives in Ocala now, is rowing at their gym and whatever the community is they live in, and I think, and that's kind of a pleasant thing. I think, that's really nice. But
yes,
if God forbid he were to get injured, I would know
exactly
what his level of activity was. So
exactly, and I think it's encouraged if you have those watches. It's like it's time to move and get up, and
absolutely.
That's all positive. I think it's great that you want people to be active. You can be competitive and compete with your friends, but of course, you could see how that could be spun in a negative way if it's not consistent with what you have previously said or testified to. So,
which that I think adds, I'm kind of glad we're having this discussion because I'm going to add that to my personal deposition preparation for particularly a younger person, but even obvious older people do this too, because the real key is to be accurate. I always tell the client, I want you to be accurate. And so a lot of times you'll have people that will minimize what's going on in their life. And when you talk to them more, you help them to appreciate how limited they are in certain things. Like maybe you used to jog every day. Now you take a shorter jog once a week, that kind of thing. And so something that gives everybody, if they use these watches, and a lot of people do now, I do, but I don't think I would get into trouble in the law.
Right. No one would see any triathlons on my watch.
To a degree, that's why I'm and this is just me. That's why I'm always careful with those kind of things. I'm glad I don't have I still have a smartphone, but I have an Android.
Yeah.
I'm just a lot more careful with that stuff. Like I don't have an Apple Watch just because I'm neurotic about stuff like that. And to that point, that's also why I'm a lot more careful now about what I post on Facebook for a couple of reasons. It's for the purposes of job, because you never know if an employer is going to be looking at you.
True.
And to that point, if I see something involving, say, an accident, I don't want to be putting anything up there that could either damage, like a claim for me if I was in an accident, or help somebody else in another case. It's just I'd rather
just not have it there at all.
Exactly. I'll take pictures. Like, let's say I get into an accident, I'll take the pictures.
Yes.
And I'll keep everything on my phone.
Yeah.
But the only one who's ever going to have access to it, unless I'm getting requests from my lawyers, would be me.
Exactly.
And I want to keep it that way just because you never know.
You never know. And that's exactly correct. Yes.
You've got it, Matt. Yeah. And that's exactly what we're trying to convey is, once it's out there on the internet, it's out there. And I always tell my clients, even if your accounts are private or you think that you've limited your audience to some extent and that you don't have any, people accessing it that unless they're your friends or you know them, that might be all well and good, but we should assume that if it's on the internet, then other people have probably seen it or have access to it.
But then again, you know what happens when you assume? You make an ass out of you and me.
That can be very
But chances are good. If it's on the internet, it's there forever.
It's there.
Yeah, it's out there.
And you should assume that the defense has access to it. You should never think that anything is really private on the internet. No matter what steps you've taken, especially nowadays, I think they've got really great investigators who can find this information. And as stealthily as you think you might have your accounts, you just, when in doubt, don't post it.
It's one of the things, and perhaps is a little generational, but people have a tendency now to publish something or post something about everything that's happening in their life, every thought they have.
It's their diary, a journal.
It's like, a little bit too much drama sometimes. And if you have a claim, we don't want that drama.
Exactly. And you made a good point about, people sometimes wanting to minimize things and maybe not shed as much light on a particular issue for whatever reason. That brings me back to a good point that I definitely think we should touch on and not forget about prior medical history or prior claims. I think it's really good for our listeners to understand how important it is to disclose that information up front.
Oh, yes. So, if you have a pre-existing medical history, which most anybody is of any age probably will have some degree.
Right.
It is absolutely relevant. I mean, it's so obviously. So let's just say, say I've had chronic back issues, pretty much, for quite a few years. I get in an automobile accident, and now it's flared up, and it's worse than it's ever been. So, in that scenario, the fact that I had past back problems does not mean that I don't have a claim. I absolutely do.
Exactly.
Because I was, the law says you have to take the person as you find them. But I do have to be very accurate about disclosing any other issues that I've had because I will destroy my credibility if I don't. And honestly, it's so difficult for people because if you have been trucking along pretty good in your life. Yes, you did have an injury before, but you kind of worked through that. It's been quite a while. You're doing pretty good. You live your life. Then you get into an accident. You have a flare-up of this. It's very easy to, and from your own point of view, probably accurate to say, this is like, I've never had anything like this.
Right.
But very important to be able to basically separate out those two things and just honestly be accurate in it. And it's so hard for people on that. It's so important. Yeah.
But actually, I do have a question. I know I have friends that have epilepsy, and that's played a factor into a traffic accident that they were in. I'm not going to get into details because that's not the point of the question. My question is, for somebody like me, I have my driver's license. I'm partially blind. I'm legally partially blind in my left eye.
Mm-hmm.
And if I were to get into an accident because somebody was coming, let's say for the sake of argument, somebody's coming from my left, I run into them because I don't see them until at the very last second and I can't hit the brakes fast enough. Would that play a factor at all in the claim from the other person?
Yes.
Yes, it would.
Yes, it would. Because in order, so it goes really both ways. But I mean, if I'm injured at the hands of somebody else, then I have to show they were negligent. They did not act as a reasonable person. So in your scenario, you and I'm sure you are mindful of this.
Oh yeah. Absolutely.
You'd have to be very aware of that limitation. You're obviously able to drive.
Yes.
And you just kind of work around that
as best as I can. Absolutely.
Right. But I mean, if you were to cause an accident because of that scenario, then it would be an evaluation of whether you were acting reasonably in that circumstance. And that's one of the things I love about the law. I love debate. And so lawyers for either side will build an argument based on the facts and how they could be interpreted.
Exactly.
But I will say, it is an issue. We do have cases from time to time where there's a sudden medical event by the defendant driver, and that causes the accident. Well, if it's truly sudden, could not have been anticipated, and there's no medical history or something that should have put that person on notice, then they weren't negligent.
Right.
And in that situation, we might be representing someone who unfortunately was injured, but the defendant was not negligent. Now, usually, in those situations, there are medical issues like you're describing in your situation, which is a relatively modest one, but one that you do deal with.
Absolutely.
That you are mindful of and you take into account. Like you're probably not going to be driving, maybe at night or whatever as much.
I have no problems driving at night. It's my biggest. My biggest thing is just being able to see coming off the left side. I got to turn my head around a little more just to be able to see. Exactly.
Right.
And I've also had trouble in the past with depth perception. That's what I was looking for.
Right.
So that plays a factor too into my driving.
Right. So like Lori said, it's going to depend on the lawyer and the circumstances, and we will, use those facts to determine how to proceed with the case. So like Lori mentioned, there's certain times where it's absolutely unforeseeable. It just comes out of the blue. There's no history of it. And so sadly, there just may not be a claim there if there is no negligence. And so that's the lawyer's job to try to find out if that's accurate. You get the records, is there a history, that sort of thing.
And that, fortunately, it's relatively unusual that comes up. And in your circumstance, as you just said, you're going to be careful in your driving situation. Now, and if somebody does something sudden that puts you in a position that they've kind of caused that. But you are going to be mindful probably in terms of the traffic you get yourself into and the situations, because you don't want to be in an accident yourself, obviously.
That's always why they tell people at driving schools, always leave yourself an out.
Absolutely.
As much as possible, always try to leave yourself an out so that way, if, God forbid, somebody stops short, you could be able to, as safely as you can, move around them so that way you don't hit anything.
Right. So that's a great tip. And I had something like that happen in a government entity case where it was a mass transit bus and the driver had a sudden medical occurrence. And initially that government entity denied the claim and said, well, it wasn't foreseeable. There's nothing that we can do. But we found more information that supported that it wasn't as sudden or unexpected as they alleged. And so the claim was actually able to move forward. So there's so many different layers to that. That's a really great question, Matt. And so if you find yourself in that circumstance where you're not really sure if there is negligence, but you've been hurt and you've been told that the other driver had some sort of medical condition, then certainly give us a call. We are wrapping up here in the studio. But of course, if you think of something or you have a question about something and we're no longer on the air, you can absolutely call us anytime, 24/7 at 727-796-8282. That's the purpose of this show, to kind of get you thinking about the legal issues that may pertain to you. As personal injury lawyers, we're doing our best to give you, the best information we can to help you along. But there's only so much we can do in a 1 hour show. So you absolutely want to give us a call at the office. So just to kind of wrap up our discussion on what we're talking about, I wanted to just briefly touch on mediation, because I had a situation come up before where a party posted about something that occurred at mediation. Yeah. And the other side heard about it. And it did almost kind of put a halt on where we were going as far as resolving the case. We were able to kind of rein it back in and get the case resolved. But I want to touch on, just kind of about the confidentiality process of mediation and just give a little tip on that, if you would.
Oh, sure. Yes. So part of any litigation lawsuit will be a court-ordered mediation. It's a settlement conference, and they are absolutely confidential. So, the mediator will speak of that, and, we will tell our clients that. In the normal situation, it shouldn't really be an issue because not too many people will be too interested in your case type thing. But you are, as a person, and it's kind of understandable that, a person would speak to somebody without thinking about it. But mediation itself is a great opportunity to get cases settled.
Right.
So there's a mediator who's usually a retired judge or a lawyer who's specially trained to handle mediation. Both sides agree on the person. And then it's basically an opportunity to facilitate settlement discussion between the parties. Everybody's zeroed in on that case in that moment. And, many, many cases do settle as a result of that process.
Right. That's the goal. So, and I think that's key. I think if you want to come in and try to get your case resolved, then the best thing to do is listen to your attorney, and do not take any information outside of those, mediation walls.
No.
Don't call your buddy and tell him what's going on. Don't post about it on social media. Listen to your lawyer and use that time in that process to see what you can do about getting your case settled. And even if you can't, there's a mediator out there who loves to say it's a preview of coming attractions. So at least what you might expect if your case doesn't settle.
Absolutely.
You've kind of already heard now what their defenses are, and you understand how they view your case and what they might actually say when it comes down to presenting the case to a jury. And so if anything, you've now at least gotten a better understanding of the defense's case. Right?
It's a step in the process. As
Exactly.
I say, I love to try cases. I know that you do as well. And we're debaters at heart.
Right.
But most cases, properly so, will end up settling at some point. And most people want that. When I hear a client say, as I did recently, "Oh, I'm ready to go to trial." It's like, well, you don't really have an idea of what you're talking about, basically. So, cases that go to trial because that's the best option for the client at that point in time.
Right.
And as I say, we as lawyers are happy to do that. But for the most part, most people are benefited by getting their case settled without the additional expense that is involved with going to trial.
Exactly.
And the risk, because you never know what 6 people from the...
You never know.
You just don't know how that's going to go. So most people will be better off by having an opportunity to get their case resolved. And mediation is a great way. It's a good part of the process towards getting that to happen, even if it doesn't happen in that moment. But classic example, I think, the social media thing that you kind of directed us to earlier, it's like, you just can't put these things out there.
You can't. Absolutely not. Time flies when you're having fun, Lori. This has been a great show. Our hour has gone by. Thank you all for listening to FLA Law on the radio. And of course, if you need to reach us at any time at the office, Parent Caulfield, Averill, Illinois, 727-796-8282. You all have a great night, folks.
All right. Be safe.